A corporation is a web of contracts. Insolvency occurs at the exact mathematical moment when a firm's liabilities exceed its assets, breaking the central promise that lenders will be repaid. When the red line of debt crosses the black line of operational assets, the company loses its balance sheet viability. For lenders, the calculus shifts instantly. The rational incentive is to strike first. They must sprint to the courthouse and seize collateral before the available pool runs dry. This triggers a midnight asset grab. Individual creditors physically dismantle the firm's operational capacity to secure their specific debts. Server racks are unbolted, delivery trucks are towed, the factory grinds to a halt. The law calls this the race of diligence. The pursuit of individual legal remedies triggers a collective operational collapse. Economists define this as a common pool problem. In an unowned fishery, every fisherman has a rational incentive to extract catch as fast as possible, guaranteeing the total depletion of the shared resource. A single creditor may secure pennies on the dollar by acting first, but that same act vaporizes the firm's going concern value, the unique premium a business holds only when its components are functioning as a whole. Without a collective rule, the race of diligence divides the assets and mathematically shrinks the firm's total value. In 1982, legal scholar Thomas Jackson published a thesis defining bankruptcy law as a system designed to protect creditors from their own destructive incentives. Jackson identified the central diagnostic. Creditors are locked in a prisoner's dilemma. Unable to coordinate, rational individual actions lead to a suboptimal result. Compounding this are strategic costs. Creditors burn resources monitoring courthouse records and policing each other, draining the recovery. Jackson proposed a thought experiment using a veil of ignorance rewind. What agreement would these creditors draft if they negotiated before they knew who would be first to the courthouse? The result is the creditor's bargain, a unanimous agreement to pool claims and preserve total value. The real-world enforcement is the automatic stay. Upon filing for bankruptcy, a legal dome drops over the assets, freezing creditors in place. It acts as a mandatory truce. The business stops hemorrhaging assets, preserving its going concern value for an orderly future sale or a structured reorganization. Jackson established a strict normative limit. Bankruptcy law exists solely to solve this collective action problem. It should not alter or redistribute the non-bankruptcy property rights the creditors initially negotiated. The automatic stay functions as the legal peace treaty required to prevent the irrational destruction of corporate wealth. But this truce opens a trapdoor. The dome protects the factory, yes, but it also shields firms that are objectively beyond saving. The legal system operates like an emergency room, dealing with two very different patients. One is bleeding but needs a simple tourniquet to survive. The other is a zombie with no pulse, and the doctor cannot tell the difference. This is a crisis of asymmetric information. Corporate managers know perfectly well if their firm is a zombie, but creditors and the court are blinded by the manager's self-interest. Managers will lie to keep a doomed firm alive. They use the automatic stay as a fortress to protect their jobs and defer the inevitable.
This creates the shareholder-creditor conflict. Once a firm is insolvent, the equity holders, the owners, have mathematically lost everything. With nothing left to lose, they are willing to gamble the remaining corporate assets on low-probability recoveries. In finance, we call this treating equity as a call option. The firm's remaining capital becomes a casino chip used to gamble for resurrection at the creditor's expense. If pleading for court protection is costless, you arrive at a pooling equilibrium. Every firm, viable or doomed, claims to be the patient that just needs a tourniquet. The signal of survival becomes entirely useless. A perfectly enforced truce accidentally creates a trapdoor, allowing doomed companies to drain capital from the broader economy. In 1994, financial economist Robert Muradian demonstrated that the high costs of a Chapter 11 reorganization are a necessary lie detector. The friction involved in Chapter 11 is notoriously severe. Massive legal fees, heavy administrative burdens, and the agony of court supervision. Muradian visualized this friction as a toll booth at the entrance to the rescue room. It requires the literal burning of cash just to enter. A truly viable firm will pay the toll. Its future cash flows and operational value are high enough to justify the brutal price of surviving. The zombie firm turns away. The massive cost of the toll destroys the mathematical upside of their gamble for resurrection. There is no longer enough capital left to place the bet. Measured, theoretical, this creates a separating equilibrium. The price of entry forces inefficient firms to self-select out of the reorganization process and proceed directly into liquidation. It is a direct application of economic signaling theory. Michael Spence won a Nobel Prize for demonstrating that a university degree acts as a signal of worker quality only because it is too expensive and difficult for an unqualified person to fake. Is the biological equivalent of the peacock's tail. The signal of health is believable only because the heavy plumage is incredibly expensive to maintain. The staggering legal costs of reorganization act exactly the same way. The friction is the information price required to filter the living from the dead. Bankruptcy law requires both pillars to function. Jackson provides the peace treaty with the automatic stay, and Meridian provides the lie detector with the cost. Neither mechanism works alone. The truce without the toll protects zombies, draining the economy. The toll without the truce allows creditors to rip apart viable firms in the race of diligence. What looks like a lumbering, inefficient legal system is actually a state of deep informational efficiency. Friction is a feature. These models provide the theoretical foundation for how corporate restructuring is supposed to function within the American judicial framework. But theory and practice inevitably collide. The question remains, does the real-world toll of Chapter 11 actually screen out doomed firms, or is the entire mechanism broken? As legal fees soar and restructuring durations stretch for years, economists are left to ask whether the cost is still an accurate lie detector, or if zombie firms are still slipping through the toll booth into the modern economy.